right, Dr. Richmond, are you ready? All right. Real quick for you guys that are on Zoom with us, our tablets would not pull up what we had for the board members, so we were just printing copies of that for everyone, which is a copy of email, and then I think the application that you guys had submitted. So I've got Dr. Davenport back. I believe Dr. Mack is on as well.
Yes, I'm on.
All right. Dr. Richmond, you want to call us back to order?
Forgot it. Who'd she send it to?
Is Pinnacle Pharmacy?
Yes, and thank you, Dr. Richmond. Dr. McCready went to grab the actual application for this if anybody at the table wanted to see it as well. Just as a quick overview, we have a couple folks on screen with us. Do you guys want to introduce yourselves?
Hello, I'm Dr. Berger with Pinnacle Pharmacy.
And I'm Jessica Hopper, also hoping to be with Pinnacle Pharmacy.
And I believe you guys are married, correct?
Yes.
That's right.
But kind of like my wife, she's not going to be on screen with you in the same place at the same time. So real quick, some of you will remember at our last reciprocity, Dr. Tate Berger appeared at the end of the meeting for his reciprocity, and they had discussed that their intent was to open a pharmacy in the state of Arkansas from Colorado. They were going to name an Arkansas pharmacist to be in charge of that. Dr. McCready should be right back in case she has anything else to add to this. But when we got their application, I believe, because it won't pull up on my pad, I believe it had Tate actually named at this time as the Arkansas pharmacist, which would mean not just having a reciprocity license, but also practicing on-site for that application. And at that point, generally we have applications that are a little bit different than may have been presented earlier or anything like that. We bring it back to the board for a further conversation. So the board members have just received a copy of this email exchange that actually Jessica sent to Dr. McCready on January 7th. So I'm going to give them just a minute to read that since it's fresh information. And then I think they may have some questions for you. Oh, and Dr. Davenport, Dr. Mack, I emailed you the actual emails that the board members are reading right now.
We got it. And we're in the same location now, so we can share if we need to.
And Dr. McCready actually emailed you their application folder so that you can look at the application itself in case you had any questions.
What's the difference between the two emails? Well,
Just how it's forwarded.
okay, I just want to make sure that I wouldn't.
I think that's just the way it printed. Printed it instead of it being.
Okay. Has the board had an opportunity to read the email? Dr. Hopper or Dr. Berger, either one of y'all, maybe you could begin by explaining the situation here.
Okay, so we currently own a pharmacy in Oklahoma as well and are looking to expand and open a pharmacy in Arkansas. Our pharmacies specifically specialize in dermatology, ophthalmology, and women's health. And so in terms of looking to open that new pharmacy, just trying to get applied for the license and move that process forward. Of course, since it's new and we're out of state, we're looking to get the licensing and insurance and all the processes in place before we really open the doors to dispense prescriptions. Don't know if you have anything to add, Tate.
I heard dermatology, what, and I think women's health,
Yeah, ophthalmology.
ophthalmology. On ophthalmology, is this like compounded ophthalmology? Is it just commercial product?
Commercial
product.
No.
Yeah.
Is all of it commercial product or is there compounding in some of it?
We will not be compounded.
So John, this Debbie, I'll ask, in the past, have we always said whoever was going to be the pharmacist in charge should be on the license? But then I'm sure things do happen and change, and eventually at times there's a different pharmacist. So they're asking on the front side, can they have him be the pick, but they won't really start filling prescriptions until they hire someone? Is that where we are?
So it's really, Dr. Mackey, there's kind of two issues. One was, at least from the staff side, I think when he had his interview for reciprocity, because he was separate from the group, I don't know that the board thought he was going to be practicing in the state of Arkansas at all, and they were going to hire somebody to run this pharmacy. And I think it is their intent to hire someone to run the pharmacy. But I think in part, unbeknownst to them, the Board of Pharmacy here has long had the ghost PIC interpretation, that if you are listing a pharmacist in charge who, isn't present in the state, or that the pharmacy permit is, whether it's in state or out of state, or is really not planning to work there, but to change to someone else, usually the board staff doesn't process that until we have who the actual person in charge that the permit would be issued in their name would be. So it might start like your 30-day clock before we can do it, but we generally don't issue permits unless the person is intending to work there. This is a little bit different. I mean, he's the owner. I don't know that I don't think they're trying to purposefully have a ghost PIC. I just think that at this stage of the game, they don't necessarily have anyone identified. But for the staff, we need to be sure, number one, is the board comfortable in putting him in a PIC role as we go through this application, or, hearing some more about the application to put you at ease to approve it through next steps. I think because both of you guys live in, is it Colorado Springs currently?
Fort Collins, but yeah, we're in Colorado.
Oh, Fort Collins, that's right. Yeah. And do you guys know when you would be hoping to actually open the pharmacy for operation to serve patients?
After we've obtained PBM contracts, so hopefully as soon as possible, but as you know, that takes a little time.
Yeah.
Do you have a pick hired?
We don't have a pick hired yet.
Okay, but and you don't intend to move to work in the state?
I will not move, but I mean, I could be there 40 hours a week to run the pharmacy if it came down to that for a short period of time.
So this is a brand new pharmacy, right?
Yeah.
Not opened its doors yet.
No.
So the issue is, and they're trying to work through foundational things. And it would seem that there were still issues related to potentially construction and naming of contracts and that sort of thing.
Yeah.
So the role of the PSC is most important. Obviously, once the pharmacy is open, somebody's there to direct it. So is it truly a pharmacy before it opens?
No, it's an applicant, and until we inspect it to approve the permit. So generally, if you apply for a pharmacy permit, there's a couple of different ways people have done that. Years back, generally people would say, hey, we're hoping to open, March 28th, and we would generally try to inspect them like the week before. Over, especially the last few years, we see a lot more examples where people say, well, we'll have it in the dry where you can tell we can secure it. We really want to go ahead and get our permit March 28th, but we're going to open at some indefinite period of time going forward. Our guidance from the board previously has been, if you're not going to open within 90 days, then you basically have to sign a memorandum with the board that you're not going to have any drugs present or anything else until you basically re-clear that with staff so that you don't have an active permit. Because if you have an active permit without the MOU, you're required to be open 40 hours a week under our retail rules for the state of Arkansas. Otherwise, it's, Dr. Fouché doesn't get to be open 8 hours a week and have another pharmacy down the street that we tell has to be open 40. We have seen issues in the past with pharmacies, and this is no allegation against either one of these pharmacists, but that once you obtain a permit, then we would see fraudulent activity with billing or either ordering drugs or billing drugs, Medicare, Medicaid fraud, and things like that, which I think is part of the reason why we have these types of requirements for the board.
So what they're really asking is an extension of time until they get all their ducks in a row as far as contracts and whatnot. To then at that point commit to hiring a PIC.
I think it's two questions. Number one is the board going to approve proceeding with the application with him as the PIC, knowing that while he doesn't intend to live here, he's saying that if need be, he could come down here and work periodically to have it open. Number two is kind of, well, if you're not even going to potentially be open within 90 days, do we get an agreement for the MOU that you're not even intending to operate at this time? So you would have a potential permit approval, but the inability to use it for any ordering or billing of drugs until a date to be determined later.
So by him coming here to work, even if it's not on a long-term change resident basis, I mean, he's not a ghost PIC.
Not if he came here to work now.
Right.
Is there any opportunity with his license that was brought before us before? Because if it was, I don't remember that, but.
Yeah, I mean, he's licensed in good standing. He'd had an
Okay.
issue in another state previously, but that had been resolved, and the board approved his reciprocity application.
Okay, so we don't have an issue with him coming and being the pick if he had to be for the short
No,
term.
I mean, he'd have to take our PIC exam, which is routine, but it's that's something we could actually email him, and he could email back.
So I would say, just from past experience, I know we do want the pick that is going to be working at the pharmacy to be on record as the pick in the application. I know we do want that. I would assume possibly something could occur in that scenario where they have to name a new pick. So I mean, to me, he didn't put in that he was going to be the pick, knowing he wasn't ever going to be the pick. He came and asked, I guess, so that it's a reasonable ask if we believe we should do that, but we do really want the actual pick on the application. So you just got to decide, do we want to fit in the rule because he did ask?
You could make a motion basically that we could send him the PIC exam, and once he passes it, proceed with the application as it is. And if they are not going to be open for more than 90 days, enter the MOU that they wouldn't use the permit until the date to be determined as part of the MOU.
Have we ever approved a permit with PIC that doesn't live in the state?
We have. It is, but it's an unusual circumstance that, most of the time we've had something like that, it's the person would be saying like, I am in the process of moving or something like that.
But we have done that. Now, I guess the question would be, how would that be any different than if somebody has been hired as a PIC, but let's say they're moving across from Texas, they're going to be the PIC, they're going through the same process.
It would be similar.
The difference seems that that person never has the intent to be the PIC. So we're,
it's a placeholder versus someone moving here.
all those other cases, that person has always become the PIC.
Yeah, and they were generally on their way to move to Arkansas or something like that. Yeah. And Dr. Berger, are you already a pharmacist in charge at your employer in Colorado?
No, I'm not currently a PIC. I have been in 7 different states, but I'm not currently.
So if on the application he was a PIC and he hasn't gotten a pharmacist hired, then it would in fact be his intention to come here to be the PIC.
Yeah.
That's not what we want. We don't intend to dispense drugs, order drugs, bill insurance until we have somebody else hired. I mean, worst case scenario, I can be the PIC, but that is not our intention.
It's not our hope. It's not our hope.
I'm sorry if I missed this already, but what is your timeline? Like, what is your plan for, like, at what point are you going to start looking for a PIC? Do you have some sort of a schedule that you're trying to follow? I know that can be kind of dependent on outside factors, but like, what is when this happens, then we'll start the hiring process.
I think at the point at which we can or even order drugs, where we have a license, we have a DEA, we're working through the process of getting enrolled with the PBMs, PSAO. We can get that PIC. We don't want to limit who we can hire because our timeline is so far out either, in terms of someone with experience or who's currently managing a pharmacy and is a PIC. Like we don't want to hire someone and pull them away from a job and not be able to follow through or come through on this PIC position either. So it depends on down the chain potentially. I mean, that being said, and in deference to this board, if we have to change the order of operations, we have to change the order of operations. But yeah, I'd imagine, a month to 6 weeks once we can get licensing and contracting moving forward.
Our usual MOU that we've done in the past has been, we expect you to be open and operational within 90 days. If you are not going to be, then we have basically a 90-day MOU. So if it gives 3 months for people to get everything in order as part of the MOU before we expect them either operate or give up your permit.
And that sounds completely fair and reasonable.
Any other questions or comments by the board? All the board, Harold, do you have any input? Do you have any thoughts or concerns about this?
I don't I see a sign.
Yes, we can't hear Harold. So Dr. Kirtley, would this, by doing this, I think because they came and asked and we have it in writing, they have to do this in 90 days and they can't open. I would feel okay with that, but that could bring up many more requests. So are we, I mean,
we've had a few in state that, but I mean, everyone was already here where they have started to open a pharmacy and would have either a construction delay or something like that. We've entered an MOU. So the MOU has been around for a few years along this, but it's been the last few years when we had pharmacies that were trying to get a permit, but not actually open and operate at that time to give them, a chance to work, whether it's their PSAO or direct contracting, trying to get their contracts in order before they were operational.
but the pig thing, I think that would probably lead others to come and want to have a pick in name only and then change it later. I think that would probably, because that used to be the big issue and everybody did it at one time.
We deal with that a lot.
Does the staff have a recommendation on this?
Our concern was it was a little bit different approach than we thought the board had been presented with at the last meeting. And generally, if it's a ghost PIC, which I mean, given he's telling the board, part of this is, he has to tell you guys that, yes, if need be, I'll be there working. But we generally don't process with a ghost PIC. And explain this. Most often it would result in someone saying, this is going to be the pharmacist. Even if they're at another job right now, it's, Dr. Smith will be our PIC, but not until we open the pharmacy is our intent and have that on the application. This one, it's a little bit different than what we generally see or process while we brought it to you guys. I mean, if he tells you this in this meeting and then he doesn't do it, then you'd probably want us to bring it back before you and you'd take the permit back or not release the MOU or something.
Could I ask what's different about this application to open a new retail pharmacy than any other one?
Well, in this instance, the name on the application is someone who does not reside for like 1,000 miles from the pharmacy. We most often would see that as a conflict with out-of-state pharmacies. We've seen it a lot with ghost pharmacist in charge or ghost Arkansas pharmacist, where you would have someone that is contracted to get paid to be the Arkansas pharmacist, even though they're never present. This one is slightly different, Harold, because he is saying, well, if we cannot find another pharmacist by the time we are trying to open the pharmacy, he's saying he will basically come down here and work 40 hours a week and basically go back and forth between Fort Collins and Little Rock.
So in the ordinary sense of situation, you would have an application where there would be a PIC that had been employed, but the pharmacy wouldn't be open for 30 days, something like that?
Yes.
Okay, so, but you still have, and the difference here is just where the PIC is located.
That's the major part of it, yes. And we've had them before, someone was going to open a pharmacy here and they're naming a PIC, and we would looking at somebody saying, I'm in the process of reciprocating and I'm moving to Little Rock. I'm going to be there X or Y date. That's what we would typically see if it was someone from another state. You had a couple of reciprocity folks today that even had come in and gotten temporary licenses to fulfill those needs and go to work in pharmacies.
So the other than a waiver or something like we're discussing here, what he would be required to do would be to hire someone who was located physically present in Arkansas to be the PIC.
Whoever the PIC is going to be has to work half the hours that the pharmacy is open up to a certain number of required hours.
And before the pharmacy is approved and opened, does the PIC have to be on site located? How does that work?
Well, like if you, on the application, we'll have like list all individuals filling prescriptions, performing any function considered to be the practice of pharmacy for this business. You may attach additional sheets, and they are the only two people listed at this time on the application. But since we know that they're not intending to move here, it throws a red flag for us of, well, how's that going to work?
Let me try one more aspect of this. Does the PIC actually perform any pharmacy duties before the store opens?
And let me add to the hypothetical, with no drugs on site.
They are, what we would say is the PIC is whose name we issue the permit in. That might be the unique aspect to this. So even if it is, if I own the pharmacy, then I am the permit holder, but I have to have a pharmacist in charge, and the permit is actually listed in that pharmacist's name. As the PIC, they are responsible, given there's a difference before or after you have drugs, they are sharing responsibility for the policies and procedures of the pharmacy, for the control and accountability of drugs and what is going to be used in the pharmacy. A lot of that has to do with once you have drugs, but even before you have drugs, you've got HIPAA training, you've got whether it's design, layout, security plans, all of that. That's the best way I think I can answer it.
I got you.
So historically, in the past, if someone's going to open up a new pharmacy, and whether that's going to be new construction or maybe a remodel of an existing space, 100% of the time, whoever the PIC is at the time of application always ends up being the PIC when it opens. We don't run into PIC change out forms.
We have them, but they're not many of them. They're generally the only ones that we have now. I mean, used to, before the board had the whole ghost PIC issue, it might be possibly more routine then, but now generally the board is wanting to see a pharmacy application that is signed by the person who's actually going to run the pharmacy. That's another aspect of it, is the application itself. When it is signed, it's signed by the ownership and by the pharmacist in charge. So the PIC is also attesting that, the procedures that are described for patient freedom of choice, patient counseling, processing, everything else is it. I think that's why the board came up with, we're not processing ghost PICs, because you have an application at that point to be issued in someone's name. You change it right before you get the application or right before you get the permit, and that person didn't sign off on any of this, and we don't know if they have any authority over it or not. So how have you guys already gotten an NPI number as a pharmacy here?
Yeah, it's just a fairly simple, like, we have an address that we're constructing, so that application is pretty simple. Doesn't ask many questions.
Yeah. I know a lot of people would just get their, like, I would get my individual one, but not for a business that doesn't exist yet.
I think it's a precedent you're setting if you say, yeah, we're okay with this.
I mean, if his understanding is he's either going to be here and work within that time or someone else, that's, better than just we're putting our name on it so you'll process it, but we're never going to do it.
If this is approved, is that going to set a precedent that creates further issues for the board and the agency on down the line?
That's our fear. Because it's once we've granted the permit, and with your background, I think you'll appreciate this greatly. If we approve the permit and then they try to change it to someone else who we would not have approved the permit for, then you have, potential claim of an ownership right to the permit, and we're denying reissuing a new permit in a new person's name because they don't qualify or there's some other issue. I mean, if it's an established pharmacy and they change the PIC, well, it's an established pharmacy here. We've already generally laid eyes on it, inspected, vetted the entire application to begin with. It's a different situation. But even then, we have pharmacies that will change PIC and we'll have to say, well, that person doesn't qualify to be a PIC at this time. Sometimes it's they need to take the test. Sometimes it is that they've already been excluded from being a PIC. If they were in the support group and they haven't been granted approval to act as a PIC yet, they would have to clear that hurdle before we could reissue a permit.
Really different.
If it wasn't unusual, you wouldn't be looking at it.
Yeah. My opinion, we need to go ahead and get the PIC here before we go forward. So when it's got their feet on the ground in the state of Arkansas. Because other than that, this thing is just gonna be, it could be floating for I don't know how long. So we need to get a pharmacist hired for that store if there's gonna be a store in that location.
Basically, find your long-term PIC before the staff proceeds with the application.
Correct. I can put that in the form of a motion if you would like.
Okay, we have a motion and a second to.
Yeah.
Because we're moving the discussion that we've had. The only path that we can see forward is to understand a promise from Dr. Berger. And then we've established that we're willing to give a new
permit
based on something that wasn't really going to be, or someone who wasn't going to be the PLC. Yeah. It just changes things, and there'll be a new twist on the circumstances next time around from whoever the following applicant is, and we've already taken a step down the path. Yep.
Let me ask you, by voting on a motion, does this create some derogatory issue? So it's not going to pose an issue for them down the road?
Not unless you're voting to try to issue a denial to the permit. If we are just sitting on it and process till another step, we would count it just like we didn't get a copy of your lease. We can't go any further till we do. So it's nothing derogatory or reported as negative action.
So are we voting basically to table action on the?
I took it as basically Dr. Newsom is saying, the permit doesn't go any further until they figure out their PIC. They can continue their construction and preparing the space and everything else, but we're not going to move forward in inspecting or issuing a permit or discussing the MOU until we know who's actually going to be the longer term plan to run it.
But they are the owners, right?
They are the owners.
Okay.
So Dr. Newsom, that was the intent of your motion?
Yes.
And Mr. Simpson? Okay. All right, so we have a motion and a second. Is there any additional discussion on the matter?
I would just add that the application is good for a year from the day we received it.
December.
So they have a full year to work this out and get it resolved and before the application expires.
Okay. So that didn't change the motion, right? All right, then all those in favor of the motion, please say aye.
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 Any opposed?
Nay.
Motion carries.
And we'll get back in touch with them if they have any questions after this. Thank you guys for joining us.
We appreciate your time. Thank you.
Thank you.
You got another seat you can sit over. First hearing. Moving down our list, we have a couple of emergency hearings we had scheduled for 1:45 or after. We're just a few minutes late on that. We'll turn it over to Ms. Vales.
Board members, we have 2 emergency hearings we need to conduct today. The first one is Sterling Distributors. Should be in your board, in your tablet under Sterling. And it is case number 2025-010 on Sterling Distributors, who has a medical gas license number 01850. We are asking that the board members consider an emergency suspension of their license pending a full disciplinary hearing. Staff feels like the public health, safety, and welfare is in jeopardy with them remaining to hold their license. The allegations in this case are that they are wholesaling GLP-1 medication, but that GLP-1 medication is fake. You'll hear from Dr. McCready on how this came to light with the Board of Pharmacy. Then I'll let you hear from Dr. Holland, who went out and laid eyes on the product and how he determined that these products were fake. So I will go ahead and let Dr. McCready tell us what she knows about how this came about on our radar.
We licensed Sterling Distributors as a medical gas DME with that permit on January 2nd of 2019. It's license MG01850. And in the application, we asked them what the products they were going to be sending, that type of thing. And they're basically just wholesaling some diabetic over-the-counter products. In the application, it says they're a wholesaler of over-the-counter drugs and devices. They do not sell prescription medications. I received a phone call and an email from an inspector in Mississippi asking if it was okay if he give my name to a investigator with Novo that was claiming that this company was shipping GLP-1s and that some of those were not, in fact, actual product. She called and I spoke with her. We talked about the issues. She explained that they had spoken with the pharmacy in Arkansas that had the product, that they had invoices. They had asked the pharmacy to quarantine that product. I sent Dr. Holland to the pharmacy to take pictures and look at the product, to get copies of invoices. Subsequently, he came back and he'll testify as to what he found there. After we put together this information, we sent a subpoena to them. I spoke with the managing officer of Sterling and told her we were sending a subpoena. She said, well, we don't ship any prescription drugs. So, well, that's not what we understand based on an email that came from one of their senior account executives that went to a pharmacy soliciting business for these products. And that's in the packet that you have. There's an email in there. There's actually a couple because I was in a pharmacy last Friday for a personal reason, and the pharmacist asked me if they were approved to ship Ozempic, Mounjaro, Trulicity, et cetera. And I said, no, they are DME. They do not ship prescription drugs. They're not licensed to ship as a wholesaler. She handed me a copy of another email from a different account executive that was asking that they go into business and buy some product from them. So I brought that in and gave it to the attorney, and I'm going to turn this over to Brandon and let him tell you what he found when he went to the pharmacy. But we do feel that this is detrimental to the patient care in the state of Arkansas. Dr. Holland.
Go to any particular order here. Let me start with Exhibit 3, which is that email.
Okay.
All right, guys. So Exhibit 3 there, that is actually the email that I obtained from the pharmacy here in Arkansas, where she was being solicited for those products, those particular products. So as Dr. McCready stated, we received confirmation from Novo that a patient had received a product that was counterfeit. You're going to see some pictures in here as well. They're going to show those products. The first couple of pictures, starting with Exhibit 4, that's going to be an invoice showing where Sterling Distributors provided Ozempic. And if you look at the bottom there, invoice for replacement Ozempic currently quarantined by pharmacy. So they had a suspect product in addition to the one that was already dispensed to a patient that was counterfeit. The pictures that you see there of the box is the product that was actually quarantined there by the pharmacy. And with something we've been provided by NABP, I was actually able to scan this product and determine that there's no GTIN number found. There's nothing to, it's a suspect product as well. But if you want to continue on here, let me see if we can find the pictures in Exhibit. Actually, what number would that be?
And what are they licensed as? A DME provider?
So yes, DME only. And as Dr. McCready pointed out in their application, they specifically say they do not provide Legend drugs. So a little further, if you guys will keep flipping, there's some more pictures here of the pen and the exhibits. Is that Exhibit 5?
Yeah, I think so.
I believe it's Exhibit 5. You guys are going to see a pen there that's labeled Ozempic. Okay.
Page 39 of the exhibit is, I believe, the pen he's talking about that's marked Ozempic.
So this was a product that was mislabeled. The measurements there, that patient, from what I understand, contacted the pharmacy and said, why does this say 0.6, 1.2, 1.8? That's not what I use. So as most of you know, as pharmacists, that's either liraglutide or Victoza. One of those products instead. It's not Ozempic.
What page is that on? I'm sorry.
Starts on page 39 through about 45.
All right, Brandon.
You're good. Yeah, there you go. 39. Yes.
Doesn't even look right.
No, it's the wrong colors and strengths and everything.
So what was their supply chain? Do we know where they got that from? The Ozempic?
Sterling Distributors or the pharmacy?
Sterling.
No, and that's kind of been something that I know we've discussed a couple of times over the years. When I go into a pharmacy, I may see a particular branded insulin that's only available at one particular retailer. They're getting these over-the-counter insulins, redistributing them, marking them up, making money off of them. But that's an over-the-counter product. That's an over-the-counter insulin that they're reselling.
So Sterling Distributors has a DME license, but they're acting as a wholesaler.
They are.
But they're not following anything that has to do with the Drug Supply Chain Act and DSCSA. You subpoenaed them, right?
Yes, sir.
So they don't even have their pedigree documents on where this product was obtained from. Or at least we don't have any proof that they...
Yeah, I sent on November 19th, I sent them a cease and desist and a subpoena that included purchase information. And they ignored that when Dr. McCready called. They're like, we don't ship Legend drugs. So I guess that was their verbal response to their subpoena. And then I sent another one in January that was due to be the information to the board in January 31st, and I got no response.
But they ship this product for resale to an Arkansas-based pharmacy. Am I understanding that correct?
Yes, sir. And if you look at Exhibit 8 too, these are, as Dr. McCready has stated, this is another email soliciting sales to a pharmacy here stating this is the inventory they currently have on hand at their warehouse, thousands of products. And if you look at the
page 54.
Page 54. So page 54, if you actually look at that, there's a Wegovy sample they're selling for $700.
And that was
It seems
information
like
we got last week, and after my cease and desist was sent.
Seems like if they didn't answer us and they didn't prove anything and we see this, why we would just take the license until they can prove it, right? I mean, you can't do
That's what we're
that.
asking
Yeah.
to do.
The board's request is for an emergency suspension of their permit at this time to ship anything. We've already sent a cease and desist that they are not able to ship prescription drugs. We are aware that we are not the only state looking into this.
There's no other discussion. I'll make the motion.
I'll second.
Got a motion and a second. Any further discussion?
Do we
I just
know
have
patients
a
have been
question.
notified?
Patients affected.
So we sent subpoena information to in part figure out who all had obtained product from them. We are only aware of a couple of pharmacies that might have in the past, based on them saying, "Hey, these are insulins. We can sell insulins." They could sell OTC insulins, but not these prescription insulin similar products. So we don't know who all obtained drugs from them due to the inability to get that information.
Is this something reportable on our part?
Yes.
Up to the FDA?
Well, we'll report it to the National Practitioner Data Bank, but we know that the drug company, at least some of the products, is already aware and investigating this themselves.
That was my question, was if there's like, this seems like it's much bigger than just the Arkansas Board of Pharmacy.
Yeah, our purview is limited to licensure, but it looks to me like there's well, there obviously is a violation of a lot of things that we're not purview to.
Yep.
So hopefully we're reporting that to all the appropriate authorities.
Further discussion? What exactly are we?
Emergency suspension of their license. That's the most you can do in this.
Okay, so voting on emergency suspension of the DME license for this Sterling company. So all in favor of the motion, please say aye.
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 Opposed? Motion carried.
Will they then have to come back to a formal?
If they request a hearing, so I'll send this to them in writing. If they request a hearing, they have 14 days to do a full hearing on it, if they would like.
Will the board have a chance to do any type of disciplinary action?
Yes.
At some point down
We
the
could
road,
probably
whether
be-
they want to be here or not?
Right, we could probably be ready for a disciplinary hearing at the same time, and I'll just do it all at one time.
Okay.
Okay, I've got one more. Thank you, Brandon. One more emergency hearing. And it is on Ms. Jamaica Tubbs. You should also be in your tablet. Sorry, Stubbs. Miss Stubbs I keep saying it wrong. Miss Tubbs entered information at her pharmacy tech renewal, indicating that there had been some criminal convictions since the last time she had renewed her license. She did provide the information that you have there in front of you. There's a felony information where she was charged with the Fraudulent Insurance Act, Class D felony, carrying up to 6 years and a $10,000 fine. And there is a document entitled Facts Constituting Reasonable Cause. Basically, the allegation is that she bound coverage with some sort of root insurance on a Honda Civic, and then her policy lapsed, and someone else drove her car, and Then the policy was reinstated at midnight, but a wreck occurred at 10:30 a.m. that morning. So she did not have insurance at the time of the wreck, but she tried to bind it at midnight, or not midnight, 2 hours later after the wreck. And obviously she was caught at that, and they charged her with fraudulent insurance act. She was convicted. You have a sentencing order. She was convicted of the D felony and given 18 months probation. That was entered into the court system on November 14, 2023. So she is still on probation, although it looks like from the documents that she's provided that she's paying her fines and court costs as she was ordered to do. But she does have some other terms of probation that she'll have to finish out. Because this was a felony offense involving a fraudulent insurance act, and we felt it was a little bit related to what might go on in a pharmacy. So we felt that we would ask her to voluntarily surrender her pharmacy tech license, mail that to the address we had in our GL system on January 7th. The certified letter got returned. So I have not heard from her regarding whether or not she wants to surrender her license. And Dr. McCray, did you have anything else you wanted to add on Ms. Tubbs?
Excuse me. I have worked with this technician before in El Dorado, so I probably need to recuse.
Okay.
I did speak with her and told her that we were mailing her a voluntary surrender based on the affidavits that she sent us when she renewed her permit. She said she didn't really want to surrender, but she'd think about it and let us know what she was going to do, but we've not heard back from her.
Do we know if she's working anywhere?
She was working at the El Dorado store.
She is currently employed.
Yeah.
The dollar amount was, I don't know if that makes a difference.
Let me look.
Was her employer aware?
On insurance fraud.
Is it an automatic felony, or is it?
It would probably be a felony amount of fraud that the insurance company was alleging.
Yeah.
I don't have any restitution in the order, so I can't say for sure she wasn't ordered to pay back any restitution, so I'm not sure that I can say the dollar amount that the insurance company would have been out, or even if they were out the money.
What was her term of probation?
18 months, and she signed the conditions of her probation in October of 2023. And I think
normally receive these until they renew, and that's why it's that time lapse.
Did she indicate that did she indicate that she had criminal problem?
Yes, she did.
She did disclose it.
She was well aware that we would have an emergency hearing if she didn't contact the board and follow through with what she needed to do. At least contact the attorney and talk with her and see what we could do. You know, we probably could have scheduled her here had she contacted the board and tried to work this out.
So the minimum her probation period is not yet over.
That's correct. By what she's given us, it looks like she's in compliance with probation. And she's also marked as a first offender. So assuming she completes probation successfully, you know, this would get expunged. Of course, we could still see it as a licensing board, but that's why we were concerned about her maintaining her pharmacy tech license due to the nature of the offense.
Is the employer aware of all of this? And do we have anything about her work history, or if there are any issues like actually relating to pharmacy, or if this is just an outside?
I have not talked to the employer.
No. And for us, the relation, I mean, it fell under any felony, but it also fell under with insurance. it may be that the employer doesn't know that it's going on. And if it's insurance fraud for a felony, if this person was at some point put on OIG exclusion list and the employer did not find out immediately, it could be a huge issue for that pharmacy.
Thank you.
Of course, depending on what the board decides to do, we will notify her employer.
So if she'd have made it 6 more weeks, hey, her issue would likely have played out.
We still would have known regardless because she had to report the felony to us.
I'm just saying that she continued for 15 months before she even had the felony.
That's the disadvantage, I guess, of not having a requirement that you report this type of thing.
When was the offense date, Ashley?
28, 21.
Because I think
September 2021.
Yeah, it happened
day
before the renewal. So we don't know when charges were filed or anything else. It may be that charges had been filed that we were not notified of at last renewal.
So it looks like I would guess by the stamp on there that charges weren't filed till August 4th, 2023.
And then resolved by October.
And then, yes, and then she went to court on October 23 and was sentenced that day to the probation.
It seems to me that whether she's trying to explain what happened and ask for a waiver or do an appeal, it all is going to amount to the same thing. She's got to sit here and explain. And I don't think we have any choice with what's in front of us to do that. And hopefully if she disagrees with it or wants to seek a waiver or what,
she can appeal and
she'll appeal. Right.
Does seem to be fairly clear. We have a motion. Is there a second?
Second.
Motion and a second. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
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 Opposed? Motion carried.
And on the record that I recuse.
Yes. Yep, should be DCRX. Lenore, I've got you in my notes.
DCRX. I didn't know. Hey, I didn't know I could watch Hulu while I was in here.
Afternoon, everybody. So I'm John Kirtley. I'm the director of the Board of Pharmacy. As you will see, we've got name tags here. Just to tell you a couple of things about this procedurally. On this side of the table, myself, Dr. McCready, Ms. Vales, we're all staff members here at the Board of Pharmacy, full-time employees in the offices. Everyone else you see, as well as our two ladies on screen, are 8 pharmacy board members that are kind of decision makers here today. If you want to tell us kind of who you are, then we can probably help kick off this discussion, and you've got a little slideshow that the board members have on their tablets as well.
Okay, great. Thank you. Well, look, we appreciate you guys giving us some time this afternoon. My name is Phil Q. I'm the president and CEO of Patient Care America. I'm here representing the company and brought two of my colleagues. Eric Tomczak, he's our Senior Director of Pharmacy Operations, as well as Mr. Bob Smith, who is our General Counsel for the organization. So, and it's colder here today than I thought it was going to be.
No, and here's the thing, our two members that you see on screen were going to come down from Northwest Arkansas, and they are supposed to have a heck of an ice storm with it getting in the 20s overnight, or else they would be here at the table. They were actually on their way here and turned around after they saw what they were already running into. So I'm going to try to as I often do, I'm probably the most verbose person at this table, but sometimes I can say words and make it shorter rather than longer for people. And I think part of that is just explain quickly a couple things of the history, and anything that I misspeak on, please straighten out. DCRX is the overall company that has the permit with us, has in the past had, under previous leadership and ownership that is completely excluded from the company now, had some major legal issues with federal dollar programs and paid some large penalties, which you've outlined.
Correct.
As part of that, the board previously had made an agreement to where the only thing that you were able to ship were some of the dialysis supplies, and I think dialysate itself. Is that correct?
That is correct.
And that was an MOU so that other drugs could not be included in that due to that previous fraud case with previous employees now, which were still in the company at the time of the MOU. The real request today, as I see it, and I'm trying to simplify this because some of our board members have seen a similar request before, is that this company, because they are doing dialysate for dialysis patients, there are bundled payments that include dialysate as well as some other.
Not quite.
Or the dialysis treatment includes the other chemicals and vitamins that are part of a bundled payment system.
Yeah, could I just expand on that just a little bit?
Sure.
Yeah. The IDPN and IPN, the dialysate nutritional infusions that we provide are not covered under the bundled payment. That is usually through a Medicare Advantage, those kind of programs, just to separate. But dialysis patients, as many of you are aware, are covered. They have bundled medications that are covered under this prospective payment plan for things such as, as John mentioned, it's medications associated with dialysis treatment. So calcitriol, so calcium, some iron, gentamicin creams, EPO is another big one. But as of January of this year, they've now added phosphate binders, which is used by literally every one of them patient on dialysis. And these dialysis centers are now required to provide those. Up until New Year's Day, patients probably through Part D would get them at their local community pharmacy. So it's created this huge demand for specialty pharmacy providers that are in the dialysis space to help provide these binder medications. So
yeah, because you're already getting paid for it.
As we are not. We don't get paid for that.
Okay.
Bundled payments go to the dialysis center.
I'm sorry. The center is getting paid for it.
That is correct.
And is contracting with you to get part of it currently and would like for you to be able to send all of it.
To supply the medications that they can't get their hands on. That's correct.
And so in the past, and you guys may or may not have ever seen this, we've had a couple of other dialysis providers that, because the dialysate is generally infused on site in the center, had gotten approval for the bundled meds that they're getting paid for all in. Correct. To provide those at the point of service for the patients in that infusion or dialysis center.
That's well said, John.
Okay. At least I said one thing right.
No, you're doing good.
Billing?
We are not. We bill directly to the dialysis center.
It's like a service you're providing and they pay you for the service.
That's correct. Right. Yeah. But all falling under, each state, licensing requirements. But yes, that is correct. No third parties, which in pharmacy, that's a blessing anymore.
But the MOU is based on a whole different set of people and circumstances, and it's just the same name.
Absolutely. That is correct.
So, I mean, they want to get the MOU reversed, even if it wasn't, or taken off, even if it didn't have to do with this new issue. They could have tried to do that, right?
Yes, ma'am. I mean, at some point we would have wanted to come before you We've got 2 pharmacists licensed with the state today, and our third, Eric, is going through the process now.
So the request is to terminate the MOU or to modify the MOU and expand it to allow for more?
I think the board has 2 choices. I mean, they built a beautiful PowerPoint that helped me get up to speed, even though we've dealt with a lot of these dialysis issues over the years.
Understood.
But for them, I mean, they're giving the examples of, the Sinelet phosphate binders. This is on page 7 of their thing. Oral vitamin D, oral iron, gentamicin cream for peritonitis. Like, those are specific. Now, I think that, the easy request for the board to consider would be that you would release the MOU so that anything that would be part of the bundled payment to the dialysis center could be provided directly by DCRX. I mean, if they add another drug to that bundled payment, then we would automatically say the MOU covers that instead of every time it changes coming forth and saying, hey, we need to add one more drug. I don't think you guys are asking to be able to send controlled substances and hormones and stuff that's not related to dialysis at this time. That would be a slightly different request than just the MOU for dialysis needs. And I may be wrong on that, Mr.
No, that's fair. I mean, our minimum request would be to let us serve the dialysis and kidney patients fully.
Yeah.
But we did just acquire a company that takes care of transplant patients, so I could see us moving down the road in that as well. I mean, we're licensed literally in every state.
Yeah, I would go ahead and ask them about transplant then, because it's something where, the dialysis is the business model right now. And there's a difference that I also outlined for you. The dialysis bundled payment drugs, the board has in the past said have been okay to send those bundled payment drugs to the dialysis center for delivery to the patient. But if there are other drugs, those dialysis patients need that are not part of the bundled system, like if I have high blood pressure and I'm on lisinopril, it's not part of the bundle, and therefore it can't go to that pickup point of care for that. It has to go direct to patient because it gets into our pickup station rules. And transplant would be kind of along the same.
That's fine. And if we want to table that for later discussion, that is fine. I mean, we're probably a year out before we even get to that. I mean, I'm just making the board fully aware. That is something I'm sure we will,
And they may very well tell you that since you've been here in person and all flown to chilly Little Rock on a day like this, they may very well be willing to let you do that in the future via Zoom since you've been in person before.
So what was the reason for the MOU in the first place? Was it
So if you look, I mean, and the thing is, in the past, there was different leadership at this company, and there were major charges that I mean, the amount that was paid, it was like $19 million for some of the charges as a civil penalty with Department of Justice. 2 of the employees were convicted of healthcare fraud in 2018 and served sentences of 24 and 60 months. The then current CEO is convicted of lying to the federal investigators 22 and served a 6-month sentence, but all of those people are gone. So when DOJ came in and had a massive fine and sent people to jail, the entire company had a changeover. It's one of those things where a lot of us would have looked at our attorney friend and said, why did we keep the same name? But at the same time, you're saying, yes, we have the same name, but it is a completely different group of people, and the
100%.
The cleanup work was done. That's why we did the MOU back then. So the patients that did have need for their dialysis treatment modality with the contracts could still get it, but it prevented any other types of claims from being introduced at that time.
Okay. So the sum of your current business is?
It's, yes, the vast majority. We do serve bundle patients in other states. Okay, that's a relatively new business, but now the demand for it has now jumped exponentially with this new entry of phosphate binders going into January 1. I mean, it's created a situation. We're one of 6 pharmacies listed by 2 of the major brand manufacturers for being able to supply some of the key branded, phosphate binders that are out there.
Absent a full discussion on what might be a future business down the road, simply expanding the MOU to be able to supply fully the set of drugs that are being used would meet.
As of today, yes, sir, it absolutely would.
So what's your request today? To terminate the MOU or to expand the MOU to allow for any bundled meds associated with the dialysis?
Can I say 1 and 1A? I mean, I would, look, if we could take care of all of our dialysis patients fully today and that was acceptable to the board, that would be fine. I would be appreciative. If we could move to eliminate the MOU altogether, that would be ideal. But, you know, I acquiesce to the board on what you're comfortable with. I'm comfortable with what we've done since we got there. I've got a long career in pharmacy and, you know, I've worked very well with the boards over the years, and that company knew day one that zero tolerance for anything. It's not right.
How long have you been operating under the new owner, whatever the right word is?
I'm going into my 5th year.
Okay.
It looks, I mean, from the staff side, many of those issues were identified in 18, DOJ and everybody solved in 19. This company has been a different company for 5 years plus. It's a completely different group of people with, and I think this may be opinion, not fact, but they are very transparent about this. And the people before them were not transparent about it. I mean, even when you look at the presentation they sent, they're like, here's everything we could tell you. I mean, it's a different group than it was. I don't know that we have great concerns or grave concerns that we need to keep the MOU versus let them operate. If we have another problem later with the new people, we'll solve it then.
Good.
So here, yeah, the dialysis side is tough on the patient choice because they've chosen the dialysis center that's getting the bundled payment. And what we've said in the past is if it's part of the bundled payment for the center, then that patient chose the center and they don't necessarily have a further freedom of choice. We've always ensured that on the non-bundled other care the patient has, that they do have patient freedom of choice. And it'll be the same thing on the transplant business. Like, correct. You know, we have our Rule 7 that, you know, if you read it now, it's very clear for the pharmacist, like they have to, if you just one day get a prescription, it's a transplant patient, you still have to reach out and you have to contact that patient and go, hey, we seem to have a prescription for you. Have you chosen us? Here's what we're going to do. Do I have approval to fill your prescription, Here's the shipping plan. If we can't get it to you in a timely manner because there's an ice storm in Northwest Arkansas, you have to have a backup plan for them. I mean, it's, you know, we have very specific rules on them. So the dialysis, in many ways, the patient has already exercised their freedom of choice with the dialysis delivery. But on the other drugs, we have very stringent rules on freedom of choice.
Just to be clear, so then, thank you, but for an MOU being in place, if we broaden it or rescind it, it has the same effect on what you're able to do.
Mostly, yes. If it's modified, it takes care of the immediate concern about being able to service dialysis patients. If it is then rescinded, then we have the full ability to use our license as any other provider in the state. So I'm not trying to be, I just wanted to make sure, you know, I delineated the two.
Okay.
Okay.
Yes. I have a question on the change of people issue.
Yes, sir.
I see that you all are an LLC. How does the ownership, the people that hold the ownership units, whatever they're called in the LLC, how do they differ from the people that held those ownership interests in the LLC at the time this problem occurred in the past?
Can I defer to Bob because I'm not an ownership?
Yes, sir. The ultimate entity is a private equity firm. Remains the same as before. However, we have a new board of directors supervise the operation of the business. And it includes other pharmacists, as well as a compliance committee within the board of directors. The officer and I report to on a regular basis. So while the legal entity still owns us, it has different people at the board level as well as in the operating firm.
Yeah, it does. Thank you.
So Harold, in non-legal terms, what does that mean?
He's an attorney also.
Just to explain my thinking on that, you had bad activity occur in the past. The operational people were punished for that. And perhaps the overall entity was punished by paying a fine. And yet the underlying ownership interest of the entity is the same and is asking to be relieved of the MOU. And I think that's just something we ought to understand when we talk about there's been a change of people. Yeah, there has, but on the underlying level, maybe you could argue that there's not. Now, I'm not saying that defeats it. I just want you to understand why I was asking.
I understand where you're coming from. Could I just make one comment on that? Based on my knowledge, okay, obviously I did my homework before I came here. And this group was very transparent about what happened. And it was hidden from them, these activities. And once it became aware, they were fully cooperative. So yes, they got financially punished, but they also were the ones that made the changes because they got caught blindsided. I'm not making excuses. The ownership group is still the same, but they were a part of the reason I came here because of their transparency, you know, and their quality individuals. So
I would add that we went into this MOU in February of 2020. We've not had any complaints, any issues at all to come before the board in this time.
I appreciate you asking the question, Harold. I think that was a good point. Maybe more discussion.
Well, in the past, if anybody's been on the MOU, which would be a whole different scenario, I'm sure, do they ever get released from it? Or, I mean, in y'all's two opinion and Ashley's, all three of you, should we release them or should we?
So we've only had a couple of MOUs that are this type of MOUs that I can recall, or that Dr. McCready can recall. And it was, you know, a severely limiting MOU. I can't recall another one that they came off of. We've had a couple of individuals that have had orders from the board that they couldn't do something unless they had approval in the future from the board. So it would be the concept of an MOU without it being spelled out that way. You know, we've had people that could not serve as a PIC until they reappeared before the board and got approval. That's a common issue with our support group. You know, we've had people that were told they couldn't do compounding of certain types unless they got future approval from the board. So we faced some of those, but this is it's not necessarily a one-off, but it's one of about three that we could probably try to go and pull.
Dr. Newsom, do you have any contribution thoughts? Dr. Boone? Ditto. Dr. Fouché?
Yes, I mean, I still have a little bit of a concern in regard to future expansion. The MOU. I mean, I have no issue at all with expanding the MOU. The reason why that should be done. Considering that it is the exact same thing. Although the company has acted very differently over the last year. That just makes me a little bit uneasy. I'd like somebody to convince me from this as well.
Dr. Jolly?
I don't have any issue with releasing them from the MOU because of the length of time. You know, it's something that occurred in 2017, so that's been almost 8 years. They've had new ownership. They've had new operational frontline folks for 5 years. I don't know if that sells you, but that's just my thoughts on. I think that the time lapse has been long enough that I would be comfortable releasing them from the MOU. But if enough board members felt strongly about just expanding their scope, I would support that as well. That's just my.
So
I think I'll lean toward the modification of the MOU to take care of the existing problem, and then come back and revisit the expansion when we have specifics on what's being done and what safeguards could be employed.
Like I said, I would support that. I think out of fairness to them, maybe we should give them a pathway where they could come back, and I think that's what you're saying, and be released from the MOU. I don't think they should be punished from now until the end of time, is my opinion. Whether that's a year or whenever they want to expand their, like you said, did you say renal transplant potentially, or
transplant?
Just transplant.
But it's 80% of kidney transplant. Yeah. I mean, our business is to be a renal solutions provider. So that is our scope.
Well, we basically say that there are certain offenses that disqualify, say, a pharmacist or a pharmacy tech from being eligible for a license. This is a somewhat different situation since we're talking about an entity as opposed to an individual. But even in the situation of an individual, when they've had a criminal issue, say, including a felony conviction, they come to us and say, this is the situation, this is the relief I want to have. And I think that's just what needs to happen if you want to expand that. Now, if we were talking about a complete change, say a sale of a business and totally new people, I'd feel different about it. But we're not changing the fundamental ownership here.
Yeah, I mean, I can't argue it legally. I'm just going by the company admitted no fault. So the LLC itself admitted no fault. And the folks that were actually convicted were frontline operational folks. So I don't have an issue with not penalizing the LLC from now to the end of time. Again, I can't argue that legally. I'm just saying it appears to me that it was the frontline operational folks that were making bad business decisions around what they were doing in terms of the fraud. I realize the company is still has responsibility there.
Well, and I'm not suggesting this as additional punishment or even continuing punishment. It's just a matter of us. We need to take things a piece at a time, a step at a time as we proceed with this situation.
Yeah, and I think the first step was the MOU in the first place, and that was step one. So I guess the question is, what's step two? And if it's expanding the MOU, I can support that. I just think at some point,
I agree.
Down the line, they should be able to come back and
totally agree with it.
Possibly get that lifted.
Any additional thoughts along that line?
Dr. Richmond, so if you're saying they would need to come back to do that, they would need to, and I'm asking kind of Harold, they would need to come back and present their whole case, not necessarily the ownership piece, but explain what they want to do in their business, how they're going to utilize it, what the safeguards are, and then see if we would want to drop the MOU. Is that what you're saying?
Yes.
I can assure you the safeguards will be the same ones we've had in place for the last 5 years.
I think it's a wise step to take it one step at a time, rather than to just say, okay, we're taking our hands entirely. We learned about it a few years ago. Just go ahead and broaden it, take our decision. And John, you mentioned possibility of them maybe being able to come back to us via Zoom or something.
Well, and I think there's, a decision is going to be made that's either modify the MOU per the timely request now, And if that's that vote, then, you know, from the staff side, we would have a couple of clarifications, like, is the board comfortable with them appearing at an informal meeting for further expansion, or is it a full board meeting? And in either one, could they appear via Zoom instead of having to all travel back here in person, since they have appeared here today? Those would be my two clarifying questions on it.
Hey, somebody want to make a motion along that line? See where we go?
Well, I think all we need to do today is the motion should be to amend the MOU to assuming they're agreeable, to expand it to cover the current situation.
For dialysis.
Yeah, for dialysis. And then after, if we adopt that motion, then we can take up what our desire would be if anything were to be done in the future.
So you want to do that in two different motions?
Or whether it requires a second motion.
Yeah, the second one wouldn't even have to be a motion, just instruction to staff.
All right, so we have a motion to expand the MOU to cover the bundling. Your second?
I'll second.
Second by Dr. Newsom. Is there any further discussion? Hearing none, all those in favor of the motion indicate by saying aye.
Aye. Aye.
Any opposed? Motion carries unanimous.
And the other is just simply for staff, if they do get, you know, solid organ transplant, be it mainly kidney, but it could be other organs.
What would staff recommend?
The biggest thing is, are you comfortable with either an informal, or do you want the full board to make the decision? The staff recommendation for me, at least, would be not make them have to fly back again if there's no further action, that we would be able to pull them up, be it soon. Other than that, I just need to know if you want that to be a full board decision or an informal decision.
I think it could be informal, and then
That's what I figured.
sometimes we punt it to formal.
Yeah, that's my fear. Is if you go to informal, then we're
if you got punt it
formal, then we're just kind of kicking.
So formal board meeting, but able to appear via Zoom for a next request. So, and the reason I'm asking that is,
I was going to say, otherwise let's plan a little warmer time of year.
Yeah. Well, we have 3 full board meetings a year, and then in the intervening months, we often have an informal that's a portion of the board. But I didn't want you to get called into an informal to be told, hey, we're actually going to punt this to the next full board meeting 2 months later. It's a straight to go.
That's fine. And you guys post your calendars. So we will know months and months in advance when looks like we may be moving into that. Okay. You know, I mean, and we can already do it in the other 49 states. So it's, you know, we would just plan ahead of time so we can come back and talk to you. I mean, look, I'm proud of what this team has done, what they've overcome. Can I ask one clarifying question based on something you had said? John, my understanding was for dialysis patients, and maybe it's different for dialysis patients, but that it had to be sent to their homes versus the clinics. In the state of Arkansas, can we ship to the clinics? Because we do it both ways depending on the state and the clinic.
So we have had a couple of other dialysis companies that, and part of this was a declaratory order when I was very early with the board, I mean, 18, 19 years ago, that it used to be that it could only go to the patient.
Right.
The board a couple of years ago made an interpretation. I'm looking at Dr. McCready because she corrects me when I misspeak a lot.
That's why I brought that up.
Yeah. Because of the fact that it is a bundled payment for the specific care of that patient, which is the delivery of their dialysis itself, whether that's dialysate and solutions, or they're sitting in a chair in the facility.
Right.
Because it was part of that bundled payment that center is responsible for delivering to them.
Correct.
We have had some of the companies that had requested and been given approval to deliver not just the dialysis treatment itself, but those related binders, vitamins, and everything part of the bundle, that they could deliver that without violating our pickup station rule.
Okay.
Because
that's helpful.
Well,
we've had the centers asking us.
So we can work through that on the staff side with you.
Okay.
I believe because we've done it for others.
Very helpful.
It is different than what we usually get is you can't run a pickup station. Right. There are very few exceptions that the board has given waivers to, and it's for things like this, that If the dialysis center is having to pay for it and you have a patient that is displaced or is homeless, for lack of a better term, or doesn't have stable housing, you don't need to send it to somewhere where they may not be, but you know for sure you have them as a dialysis patient and they've already used their freedom of choice to choose that center for that care. So the bundled part, we can work with you. And
that makes a ton of sense. We were already gearing up going, you know, if our conversation went well today, you know, that was a question I was going to ask the team. So since we got you.
What we would do is basically update the MOU to be sure it's open for any of the other bundled payment, you know, dialysis needs of those patients. And then as you've heard, when you have need for further expansion, if something else gets added to the bundle, we will have that encompassed in the current MOU where you wouldn't have to do this again. If you have another approach of business.
The formulary expands for bundled, it's assumed.
It's assumed to be included.
Understood. Yeah. Understood.
Because January was a big change for that.
Oh, they're rocking on their heels right now. Because now they've got a tremendous amount of liability on themselves.
Huge.
Yeah. So we are really going hard to try to help them, and so far so good. And we do offer compliance packaging if the centers desire that. So.
We have a different MOU for that. If you're doing multiple dose packaging, like you're doing like M&M strips, basically. They look like Halloween M&M packs, or it's a card with stuff. We actually have an MOU for that you would be able to sign, but it helps to prevent anyone saying that you had a misbranded product because it had multiple products with multiple labels.
Okay,
from a packaging perspective.
We'll look into that.
Yeah, we can send that to you. It's easy.
Again, we're very transparent.
Yeah.
But it's all about the patient at the end of the day.
Absolutely.
So, but we appreciate the consideration, all of you, and the time.
Yeah. Thank you guys.
Appreciate the job you guys do. These patients are sick. And appreciate the service you're providing. It's tough to operate in a bundled model. And I know you're not necessarily in the bundle, but your customers are. And so we know how tentative that can be. So thanks for all the work you do.
No, we appreciate it. And thank you all.
Absolutely.
Anything else?
No, you need to get some good food while you're in Arkansas. There's plenty of it.
Downstairs at Samantha's.
Thank you. Absolutely.
Have such a
Thank you guys. We can probably skip Gene's cell. They're not waiting on us. Come on up. Where they give us a presentation? Oh, there you go. Just be sure they know we weren't there. I just went haywire. Oh, I've got it sideways, that's why. If I can get my tablet to work again. All right, if you guys want to tell us who all we're looking at, then we can probably help maybe speed this one along too.
First time with you guys. Yeah. It is a little better weather though.
I know, you brought it with you. It's in our weather. Yeah, your weather's drunk in our front yard right now. Man.
I will go around the director of rules and things. Also, in our typical watering style, we come to you as for patient care. Laura and Kim introduce themselves.
If you'll hit push, it'll turn green, and then Dr. Mack and Dr. Davenport, there you go, can hear you.
I will start over.
There you go.
Nobody ever tells me I need a microphone. She didn't need her. I'm Laura Watkins. I'm the Director of Professional Practices. My team oversees pharmacy practice, compliance, and our central specialty and mail service pharmacies that actually ship into all 50 states and some U.S. territories. So I will be supporting this new pharmacy, and I'll pass it to Kim for her introduction.
Hi, everybody. Thanks so much for letting us come visit you today. Even though it's cold, I'm going to take it, right? So I'm Kim Tedesco. I'm Director of Gene and Cell Pharmacy Operations at Walgreens, and want to talk a little bit about Gene and Cell. I'm sure you guys are hearing a lot about it. It is, I've heard it referred to as the avalanche that's coming for pharmacy. So very exciting times. And I think pharmacy is really very poised to be the center of this. So I'm looking forward to the discussion today.
So as you guys will see, they have a presentation in your on your tablets that helps to explain for any of you that are not have not seen what gene and cell services or gene and cell therapy would encompass. For most of our board members, so that you ladies know as well, we had from the last legislative session a piece of legislation called Gold Card legislation, and the board had to review any drugs or drug therapy to see if it would be approved to have a prior authorization in the future. And several of those drugs are the $1 to $3.5 million gene or cell therapy services. My thought process on this is that these are drugs that oftentimes you have someone with a genetic disorder that this single treatment is an absolutely life-altering genetic correction on, but they are extremely rare and have different handling issues, which you can speak to better than I can.
Yeah, absolutely. So just kind of high level, I promise there won't be a biology test. We've got cell therapy, which is the transfer of cells, and they can take someone's own cells within their body, take them out, modify them, and then infuse them back into that same patient. Or they can take a donor cell and do the same thing and infuse it to, a broader range. Then we've got gene therapy, which is actually editing the DNA. So we can do gene addition, gene silencing, gene modification. You're right, John, these products are $1 to $5 million typically for a single dose. And these are patients that may have a very rare disease, maybe few patients. You'll see later on in the slide deck, there's a slide that talks about the pipeline, which is a little bit, really kind of tells a story about what's coming down the pike. But within the deck, just a few things that are really different with gene and cell pharmacy. And that, again, these are very complex conditions. You have to follow these patients for up to 15 years after they receive these therapies. So how do you engage with a patient after, they are cured of sickle cell, right? So we built a center of excellence in Pittsburgh to solve for all of these. So we did not roll it into our specialty line of business. We carved it out because we knew that this was very, very different. The administration sites are very limited. So pharma actually does an authorized treatment site list. So those are the only places where these patients can get those therapies. So oftentimes, most of the times, patients and caregivers, entire families are uprooting their whole family to move out of state for months on end to get these therapies. Lot of coordination. So when you think about, a prescription comes in typically and you're working with one prescriber, that is not the case here. You are talking about, a oncologist and then a gene and cell specialist. They may have a patient care coordinator. They have a social worker. And then you've got all of the things that we're doing, right? From a logistics standpoint and social determinants of health and solving for all of those things. And then the logistics and shelf life of these products are very, very fragile. So you can imagine with cells or blood that they are fragile, but there is a product out there that only has a 4-hour shelf life from when it's manufactured to when it has to be implanted in the baby. And for that product itself, it's for congenital athymia, babies born without a thymus, typically have a 2-year lifespan. And then they get this, it's implanted in their thigh and they regrow their thymus. It literally saves their life. I would encourage you guys, if you haven't seen any of the stories around gene and cell, go out on the internet and just listen to a few, because I think it really brings you back to why you became a pharmacist. I've been a pharmacist for a few years. Wink, wink. And I always remember them talking about this whenever I first graduated. And I thought, you know, that's so like Star Wars type thing. And now for it to be here and seeing people being cured of sickle cell and cured of hemophilia. It's just incredible. So I would encourage you guys to go and watch those. We've got some pictures of the site. It's 18,000 square feet. We have 4 telehealth studios really built around collaboration. So we know that all of these different stakeholders are going to have to interact in a way and get them together. And we've created ways to do that. And then that last slide is the one that I wanted to tell you guys about, the graph with all the dots on it. Crazy. That is the pipeline of what's coming for Gene and Cell. So there are 1,500 products in some form of clinical trials. So, and there's, you know, the rare diseases, but there are things like autoimmune, Alzheimer's, diabetes that are right on the cusp of getting approved. So large patient populations are going to be served here in the very near future. The FDA has said that they'll approve 10 to 20 products each year, starting this year through 2032. So when we say it's moving fast, it really is moving fast. But I say that, you know, we went through all of this with specialty pharmacy, right? This is obviously a little bit different, but specialty pharmacy, I think this gives us a good foundation to kind of build off of. But this is the specialty pharmacy 2.0. So really taking those lessons and doing something, you know, better and different as we move forward to serve these patients. So we are asking for licensure. We do not have a product right now that we are dispensing. We got licensed April 4th in Pennsylvania, and I think we're up to 45 licenses that have come in from non-resident states, but we aren't actively dispensing at the moment. It's kind of what comes first, the chicken or the egg, right? We want to be able to have all of the things in place and have that foundation so that if we do win a product, we're able to serve patients in your great state.
So we just got application we've been discussing some of this for a little bit of time because traditionally we require an operational inspection and a pharmacy to be open for 6 months. When they've been open 6 months, but they don't have products to get an operational inspection. Their request, and our staff doesn't have any problem with this, is basically waiving that pre-operational inspection, because if there is the need to get one of these drugs, I mean, this is all 7-figure drugs, and if the need were to arise in the state of Arkansas through a newborn at Children's or something, we would want them to be able to go ahead and get their permit to ship, even if it's the first time they ever ship.
Just to be clear, we've been doing cell therapy in the state of Arkansas since 2018 or 19.
Mm-hmm.
Okay, so maybe even longer than that at Children's for Zolgensma and some of the other ones. So just to be clear as to what you're doing, I just want to make sure I'm not misunderstanding.
Mm-hmm.
If it's a cell therapy and a patient has to schedule an apheresis appointment and get their cells drawn,
mm-hmm.
just to be clear, you're not manipulating those cells and attaching a cellular therapy to the cells and ship them back.
Correct.
Are you a third-party logistics provider? What are you doing?
So we will actually buy the product from the manufacturer. So we're assuming that financial risk. Mm-hmm. So it will come to the pharmacy for us to do, you know, a normal pharmacy validation, and then it will go to that children's hospital center, authorized treatment center for that administration to the patient.
Okay.
So we are the ones, kind of like any other pharmacy where, you know, you're the dispenser.
So some therapies are already commercial. They don't require a patient's cells, but some do require that. And so you ship the cells out to California, for example. They attach the product to the cells to be reinfused back into the patient. Are you saying that that's going to come to you first and then you're going to dispense it?
Correct.
So you're a third-party logistic provider at that point, or you're saying you're a pharmacy?
We're a pharmacy dispenser.
Mm-hmm. Yeah. And the part of this probably is, you know, traditionally a lot of what you're thinking about has all been research-based.
Right.
And that way I've
been dealing with commercial products since 2000.
So, but that commercial entity would therefore have a wholesale distributor permit to be able to ship it back to you.
It's all third-party logistic providers right now for CAR-T. So there's a middleman basically that just coordinates the logistics of it. I'm just trying to understand more kind of what your ask is and what service you're actually providing. It sounds like you're taking on the financial responsibility.
Yeah. And that's really kind of where we came into this space. I think early on, pharma thought that they would do direct from the manufacturer to the treatment site. But given the price point, health systems just don't have the money to support that, right? If you have 20 sickle cell patients, you're going to have $60 million on your books, right? It's just not feasible. So I think they really see us as a solution in that space, being able to navigate not only the financial piece, but the reimbursement piece. We've heard that a lot of physicians, health systems aren't versed in that navigation of how to get letters of agreement and do all of that contracting work that's needed in this space for reimbursement.
So you take on the risk of getting paid.
Mm-hmm.
You take that off of
the health system or the treatment center.
Mm-hmm. Okay. So the picture, there's actual facility in Pittsburgh.
There is.
So would there, maybe I don't understand this, but would there be a physical facility in Arkansas? Is there?
No, it would be in Pittsburgh. That's our center of excellence. So kind of the heartbeat of all things gene and cell. So the referral would come into that space. We're doing the clinical management of the patient, the benefits investigation, navigation, we're coordinating logistics, making sure we've got those real-time monitors for that product, you know, given it's going through the supply chain. And then we would do that dispense to that treatment center.
And we've been inspected. I just want to clarify too. We have been inspected by the Board of Pharmacy. So they've been on site, they've checked everything. But the operational, as John said, like the actual, like showing the label and all the, you know, that we have a product, we haven't moved a product. And so Pennsylvania says, well, we can give you the inspection. We've issued you a license, but we can't do an operational. And so we're willing to follow up with an operational. We just don't know when that will be. And then we've also reached out to John and Brenda with like VPP, like depending on, you know, the timing of it, we will make sure there's an entity that brings that back to you. So you waive the requirement until we have something to move, and then we're willing and able to give you that operational inspection.
So it would be that facility inspected. So then are you fencing into Arkansas?
Yes, if there was a treatment center.
If the center is here.
If there was a treatment center here, yeah. I'm sorry, John.
And as this expands, you know, to keep in mind, Walgreens is one of the companies that you have previously approved that if there's a limited distribution product that can only go through a specific pharmacy, but they don't want to ship it all the way to a patient to wind up on the curb or hoping the patient's home, we have allowed them to ship it to their local pharmacy location for specific patient pickup and in that pharmacy, much like Central Fill.
That's getting at a question I have. I'm all for gene therapy. I'm all for pharmacies and pharmacists being involved in this, but I don't understand how they fit under our regulatory authority for pharmacies and pharmacists.
Well, in this example, I mean, they are literally taking these therapies, which are going, I mean, they're FDA approved, much like a drug. It's Food and Drug Administration. Well, it's not food, so therefore it falls under drug. And since it's patient specific, their pharmacy permit would allow them to interact for that patient and either ship it directly to the point of administration or to the patient or to a local location for pickup on that specific patient's needs. So they are acting as a pharmacy to legally label and ship that patient specific treatment.
Well, I'm thinking more basic than that. You're saying that the cells, as they've been altered, are counted as drugs?
Correct.
Yes.
Yeah. They have an NDC and are approved by the FDA. Yeah.
And there are some of these that might not be a patient's tagged cells. It could be donor cells. It could be some other correction. I mean, like I have a friend who had sickle cell and, you know, has been cured from it, not from this, but from, you know, bone marrow transplant from a donor. And I don't even know that they know who the donor was. But even with blood products and things like that, you know, they'll assign drug codes to that and treat it as a drug for secure chain of operations, basically.
Okay, thank you.
It's fascinating.
It really is.
So it would require the drug to go to the Walgreens.
It could.
Rodney, will you turn your mic on, please?
Rodney was asking under our law if it would have to go to a local Walgreens. It would not. That is one option that they have, is that it could go to a local Walgreens. It could go directly to the patient themselves, or if it is a drug that can only be administered to the patient, like a radiopharmaceutical, it could go to the location that it has to be administered. And on most of these, most of these, it's going to have to be a specific type of center of excellence to even be eligible to treat a patient with that. Okay. The example I would give is, it could be, Children's Hospital, that a patient from Searcy gets referred to that center that is approved, and then the only limited distribution point where they can actually obtain it through would be this pharmacy, because that's because the post-marketing surveillance on these truly orphan issues is so significant and such a long length of time, they will only allow a couple of places in the world to carry it.
Yeah.
Okay. Good. It gave me a little heartburn to think that.
Yeah.
You could interject this going to a patient at their home.
Yeah. So many things to consider, right? So
yeah, but Rodney, our board member Richmond, sorry. I think one thing that you bring up, and John and Brendan, I had this conversation, is this keeps the pharmacist at the center of care. And I think it's so important that we as regulators don't look at like rules or laws and not make the accommodation when we want to protect patient health and keep the pharmacist a part of that continuum of care, to your point. To be able to monitor them, and you're not going to do it in a busy community pharmacy and give the patient. So I think this is the right approach. It's just, we have a lot of rules and things on the books that we just have to come to you and say, okay, can we navigate through this? There's nothing to hide here. We're just trying to figure out how we can not have an operational inspection, but give you everything else for the license.
And I see it says that the facility is 5 miles from the airport. Yeah. Like I'm familiar with Pittsburgh.
Oh.
So like literally where? I'm just curious.
In like Coriopolis, like, where Robinson Town Center is, a little bit before that. So very, very close.
I used to teach at the University of Pittsburgh.
Oh, perfect. They're actually coming out to visit. And I would ask if you guys are ever in the area or would like to come and visit the site. It has a very innovative feel. I mean, I think, when you see the slides around what is coming and how important this work is, it sucks you in. I'm just so fascinated by it, but I would love for you guys to come and see it. It really is a very unique space.
If we did, would you throw in a Permane sandwich?
I promise.
We're never going to get through a meeting without hearing about a Permane sandwich.
So I had a follow-up question.
Sure.
Is there any cellular gene therapy you're aware of that's self-administered by the patient?
No.
Is there any cellular gene therapy that you're aware of that it would not be most appropriate to ship it to the health center that's actually been accredited to administer it?
I'm sorry, what was the last part? I missed that.
You're going to be shipping to a health center that's
Correct.
accredited to give it, right?
Correct.
I mean, that's the business model, right?
Correct.
I'm not saying there won't be something 10 years from now that's not self-administered.
Right.
Who knows?
But right now.
But these are not like low-risk drugs.
Oh, no, right.
You have to monitor the patient. In some cases, you got to keep them in your hospital for 20 days.
Yep.
For 30 days or 60 days. So your business model is really just to ship directly to the health facility.
Correct.
Take the financial burden off the health facility. You handle the administrative part, for lack of a better term, and the drug shipment part. And that's what you're going to be doing, correct?
Correct. Okay. And then that clinical management, of the patient from the long-term follow-up. Exactly.
And I think where the ship to patient directly or to the Walgreens store would be pre and post meds, antibiotics, steroids, other things like that may go along with that therapy, that they would start treatment prior to the actual injection of the gene and cell product.
Yeah, part of the protocol.
Yeah.
The request is basically to go ahead and approve proceeding with the application, understanding that no one knows when they'll get the first prescription. And we also can't guarantee that if they get one and it's needed to be turned around in 4 hours, you can't say the Board of Pharmacy is going to be able to do an operational inspection in that specific of a time.
So are you issuing a provisional permit now?
No, they've got they've got an inspection and they've been open for 6 months. They just did not have drug on site when the inspection happened because the drug may turn around immediately upon receipt.
And I think that's where we're just a good partner and coming to you saying, hey, we need a solution. Like, you know, I don't need to put amoxicillin on the shelf to pretend that I'm going to dispense amoxicillin, because we wanted to be honest in what we're doing and is there a solution for us to follow up with that operational inspection when it comes. Yeah.
Brian, you want to put that in a motion?
Sure. Motion to approve the permit. Is there anything else needs to be on there besides that?
No.
Second. Do we need to have them send us a section?
We've got one. Once they get another one, they'll send it to us.
Okay, we have a motion and a second. Any other discussion? Hearing none. All those in favor of the motion, please signify by saying aye.
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 Any opposed? Motion passes unanimous.
Thank you.
Thank you so much for your time and consideration. Much appreciated.
Don't tempt Roddy.
Cup of cola and cheese.
See?
I think we're good.
I'd have had Sam Alexander here. You want to take a 5-minute break to see if our 3 o'clock made it? Today, right? Okay. Yeah, we'll check on that. We'll be right back. You guys ready to start back?
Yeah,
I'm like, I thought I had my head twisted wrong. All right, I see Dr. Mack, got Dr. Davenport. Her screen is there for us. All right. Rebecca, you want to tell us who you are and who you're with? Oh, yep, there you go.
Okay, I'm Rebecca. I am the pharmacist in charge at Sam Alexander Pharmacy in Harrison, Arkansas.
And so Rebecca's here today. She had reached out to me about a week and a half ago. They had actually gotten the retail files from another pharmacy that's no longer doing retail pharmacy. They're concentrating just on their compound efforts, which has completely changed the workload and the amount of busy that they are both at Sam Alexander and at Pointer.
Yes, sir.
Which are two, related co-owned pharmacies that have a linked system. So they're asking, would it be something they could seek approval for to be able to do order entry or processing or help some workload balancing between the two? And my suggestion to her was, you probably want to do more than just ask for offsite order entry. Go ahead and ask for central fill, so that if they have either multi-dose bubble packaging or compliance packaging or anything else at one facility versus the other, or as we've had a discussion before, you're on a different day and one store is open longer hours on Saturday than the other, you can still pull out that central fill or that central processing kind of cloud-based computer system and fill at the other store with central fill or including offsite and everything above. So it is a usual kind of request for us that I went ahead and got her on the agenda rather than making her wait till June, knowing they have some acute needs right now. And you can probably tell us how busy you guys have been and how busy you are now and kind of what you're wanting to do.
So I was pick at Berryville at Pointer for 6 years. And then I went to Sam Alexander, became pick there. So I'm familiar with Berryville, familiar with the doctors. We work a lot with people in Eureka as well as Green Forest, very rural. So we went from doing about 150 to over 400. It's been a trip for the last week for sure. But we definitely need to be able to have that opportunity to help from Sam Alexander if we can. Mostly 4 of my queues would be helpful: data entry, adjudication, insurance issues, contact manager, contacting the providers, and then a pre-verification.
How many do you fill at Sam Alexander?
Usually around 500.
Okay, so you're wanting the workload balance from Sam Alexander to the Pointer store?
I mean, just between the two. I mean, it just depends on the day because it's so new. Like, we're not totally sure how it's going to look because we bought the files. We're essentially kind of inputting them from the start. It's not just coming in as e-scripts. We bought them from Economy, so it's kind of double the work right now.
Yeah.
But I have other pharmacists at Sam, so like sometimes I might be going back and forth, just figuring out where I'm needed at the time. And I'm in contact with the pharmacist in charge at Berryville, so we contact each other when something's needed.
So John, when we approve central fill, are we by default approving one location for the central fill?
No.
Or any other?
The approach that I have taken, and I think the board has as well, is especially if you have 2 locations like this, we're fairly agnostic as to which does what in the process. We're allowing them to work together to see how the balance works best for them. So when we did this, just like with offsite order entry, years and years ago, if we approved, Walmart, well, they had this many pharmacies, and we didn't say pharmacy number 1 can only do work for pharmacy number 17. It was, y'all figure out how it works between the 2 of you and do that. So it could be a situation where, for their 2 stores, one of them may have specialty drugs that the other one doesn't have. So they could do that as central fill because of their contract and they're buying from the wholesaler for that location. If they are short-staffed at the one that usually has better staff and it's slow at the second store, they could do it. It's bi-directional, basically. Yeah. Central fill allows you to send product patient specific to the other location. So it's not a pickup station by the definition of pickup station because it's another pharmacy. We would call it central fill, but you could send it straight to patient to the other location. And because with Central Fill, we include offsite order entry, they could also help each other just on the order entry, pre-verification, adjudication, and all that. It's the kind of the catch-all for whatever might arise in those models.
I did, yes.
Yeah.
I don't know that Central Fill will happen right now, but it just happened in the files came in last Monday, so we're a little early, but I know that it's going to have to happen because I can already see staffing issues right now.
Central pickup there's just a difference of like who owns the drugs. When you start doing a central fill, I know there's some DEA issues that come into it. And so I think a lot of times it's easier to do a central pickup. And I'm not sure that's an official term, but it's filled at another store. The drug doesn't actually get invoiced to the new store, but it's kind of being billed on one store's numbers and then carried over there.
The easy request for us. I mean, in this one, it's also easy because they're co-owned, same ownership. So instead of having to worry about the specifics of contractual relationships, it's same corporation.
So it's the same LLC or?
Yes, sir.
I mean, this seems in line with what we've approved in the past.
That's exactly what I told Rebecca. I said, you'll have to drive 3 hours to Little Rock, but it'll most likely be an easy request.
And y'all,
because we've modeled this several times.
Have y'all reviewed the policy and procedure?
It's very straightforward, and they have a shared database system already. Like when we started this years ago, we would have to worry about, do these two stores even have the ability to have a real-time shared database, or how do I log from my computer into your computer? It's already there. Like she could already do this.
Just have a toggle, and I just choose, and I can see both at once or choose one or the other.
I'd make a motion to approve.
Okay, we have a motion and a second. Any additional discussion? Hearing none, all those in favor of the motion, please say aye.
Aye. Aye.
Any opposed? Motion passes unanimously.
You're good to go. We'll put a note in your file.
Thank you.
You're not allowed any weather on the road.
There you go. Thanks for coming in, Rebecca. I don't have anything else today. Do you have anything other than dates? Yeah. Just, sometime before the end of the meeting tomorrow, we've got to determine our June board meeting dates. And then we also need to see about any possible informals. It's usually the second Tuesday, which would be June 10th and 11th. Yeah. And I was going to say, last year you did move it to the first week.
When is the APA?
I believe it is the 7th, or is it the 13th? See, remember. Says, yeah, last year was the 5th through the 7th. I don't have their 25 meeting. I can figure that out though. I can have it for you by tomorrow. There we go. Yeah, I'll ask them to make sure they haven't had any like hotel event changes or anything. I'm supposed to be out of state the 11th through the 13th, but I can go a day late. Well, I can miss half a day if I need to. probably run into something else I'm supposed to do, but I just don't have on my calendar yet. Talking about June. Either 3rd, 4th, or 10th, 11th. I can verify that by tomorrow to see exactly when theirs is. Counselor, we need what, a full day or 2 days of formal, probably a 2-day formal meeting for a informal or formal? Yeah, I think we're probably gonna have to bump to April then, because there's most of Arkansas spring break that starts the 22nd, but surrounding areas are the 15th. April 8th, 9th. '15th, 16th. Hopefully we'll have it filed by then. Okay. I could do either one of those.
Is that just for informal, or what did you say?
That's for informal. That's our priority at the moment.
Okay.
Because we've got applicants waiting on informal, right? Yeah, and some medication errors that we'll have as well. Yeah, the 19th or the 18th will be Good Friday for people. Yeah. Yeah. You want to put both those on your calendar? 16, 17, 22nd, 23rd, and we can finalize one of the others, let everybody check overnight.
Wait,
right.
The only person we can hear is John. So is it 15th, 16th, or 16th, 17th?
So we're looking at 16th, 17th, or 22nd, 23rd for informal, which doesn't have to be everybody for that. Nope. 23, 24. So if you want to do the informal in April, just let us know tomorrow which one does or does not work for you. 16th, 17th, or 22nd, or 23rd, 24th. Yeah, 23rd, 24th, Wednesday, Thursday. That's the request I heard from the other end of the table.
That's the dates under discussion with you, Johnson.
I'm going to make sure with the association which one is their dates. We generally try to have our meeting before their meeting, but I'll make sure that's not where we could do June 3rd, 4th, or 10th, 11th. I have to ask Lena. I know she had paperwork out for it. I've had a couple of folks ask. Anything else you got? Ashley is smiling because she's got potential dates coming. Dr. Boone asked, I'll double check to see if we've gotten our NABP approval for travel on that meeting, which will be in May. That's all I've got for today. We're scheduled to start back at 9 o'clock tomorrow with CE hearings. Yeah. Yep. We got hearing officer all day tomorrow. I think we took one thing off the agenda, so we'll still, and we have discussed this. more than once, but you know, what we have told people involved in hearings is that we have our board meeting scheduled until 4:30 in the afternoon. Like, we cannot expect board members with significant travel times, potential weather, as well as hearing officers and court reporters to expect to stay here till 6 or 8 o'clock at night. So if anybody doesn't like that decision, I made it. If you love that decision, it was Ashley's idea first, giving credit where it's due. But I agree with it. If we continue to have meetings that run for hours over, we will not be able to get volunteer hearing officers and court reporters and everything else. The other thing is, with some of our building stuff, it is very difficult to get even to our floor after, 4:30 in the afternoon because of the way that the security works with elevators and everything else. So if someone had to go out to their car to get something, they might have to walk up 6 flights of steps to get back in the office, and that's not doable or that's not a conscientious decision. Until June. Yeah. Like, we'll find a stopping point. If we're at a stopping point at 4:15 and you go, this is going to take 3 more hours, then we'll probably call it at that point to respect the time that we've asked for our board members and other folks to be here. So we will, when we look at the agenda and we have things that we are actually worried about being an issue, we have a police officer. And if we're just a little bit worried, we got a Brian Jolly.
52 years old
now. Yeah. And I mean, generally speaking, like, we have some cases where we'll go, we're going to need somebody here that day. And that's kind of how we've done it.
I was just curious. I haven't seen it.
Yeah.
Usually 1 or 2.
Yeah, Rick, or yeah. I mean, it's been a minute since we really had, other than, one case we've got an appeal on, but yeah. Anyway, that's all I've got. Thank you, guys. We will see you in the morning.